The committee will come back to order. Chair rules that the amendment does not fit under the title. Representative Michaelson-Janae.
Thank you, Mr. Chair. I move Amendment L36 and ask for it to be displayed.
Members, you've heard the motion. That's a proper motion, and we're waiting for it to be properly displayed. It is properly displayed.
L36 was created at the request of DOI to create an effective date of 2025 because carriers are already preparing for their 2024 plans, clarifies how coverage requirements apply to grandfathered plans, and clarified that DOI has the ability to create rules. We ask for an aye vote.
Is there any further discussion on L036? Seeing none, the question before us is the adoption of L036 to Senate Bill 189. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. L36 is adopted. To the bill, Representative Garcia.
Mr. Chair, I move L047 to Senate Bill 189.
That is a proper motion.
And ask for it to be displayed properly.
That is a proper motion, and it is properly displayed. Representative
What?
Garcia.
What L047 does is a technical fix to align two parts of statute regarding preventative service requirements. It clarifies that DOI has the ability to create rules to implement this section, and I ask for an aye vote.
Is there any further discussion on amendment? Representative Brown.
Thank you, Mr. Chair. I want to address this amendment. I think it's important that we talk a little bit about preventive services in Colorado law and in federal statute. This amendment helps to clarify what particular preventive services that might be available to folks. And the bill in general, by doing this, the bill in general ensures that individuals with private insurance can access different reproductive health services and treatment for sexually transmitted infections and abortion care. And the reason that preventive services are important is because for decades, the American healthcare system has been a sick care system and not a healthcare system. It has waited until people get sick in order to treat them. Mitt Romney famously said that we provide health care for people who don't have insurance. If someone gets a heart attack, they don't sit in their apartment and die. We pick them up in an ambulance and we take them to a hospital and we give them care, and different states do this differently. And in fact, Mitt Romney isn't wrong that we have historically done it that way. And that is the most expensive way to provide care, and it is also provides the worst outcomes. It means that people who get seriously sick or injured before they receive care, it means dialysis patients are trying to manage their disease by using emergency rooms, and this was the practice for folks in various parts of the criminal justice system and for folks who lack documentation up until very recently. The Affordable Care Act and the conforming statute that we passed in Colorado fundamentally changes this. It began to promote a healthcare system for the first time, and it promotes and incentivizes care that prevents serious disease. Cost is a huge barrier to care, and the regulations under the ACA and the regulations under our Colorado statutes in Title 10 cost are very, they help people control the cost of their care. So I ask for an aye vote. Thank you.
The committee will go into a brief recess. The committee will come back to order. Representative Michelson-Janay.
Thank you, Mr. Chair. I renew my request for an aye vote on Amendment L47.
Is there any further discussion on Amendment L47? Seeing none, the motion before us is the passage of L47 to Senate Bill 189. All those in favor say aye. Aye. All those opposed, no. The ayes have it. L47 is adopted. To the bill, Representative Bottoms.
So it appears that the next level of debate that we have now for amendments is zero, because everything is going to be brought to the chair and it's going to be knocked down. So I'd like to, the first step of this is to request that the bill be read at length.
That is a proper motion.
First Regular Session 74th General Assembly State of Colorado re-engrossed. This version includes all amendments adopted in the House of Introduction LLSNO. 23 to 532.03 Brita Darling X 2241 Senate Bill 23 to 189. Senate Committees House Committees Health and Human Services Appropriations. A Bill for an Act. 101 concerning increasing access to reproductive health care. 102 services, and, in connection therewith, making an 103 appropriation. Bill Summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.gov. Sections 1, 2, 3, and 5 of the bill change the defined term HIV infection prevention drug, as it appears and is used in several areas of law, to HIV prevention drug. Section 2 also adds the Women's Preventive Services Guidelines of the Senate amended third reading March 22, 2023. Senate amended second reading March 21, 2023. Senate sponsorship Moreno and Cutter, Gonzalez, Jaquez Lewis, Marchman, Winter F., Buckner, Coleman, Danielson, Fenberg, Fields, Ginal, Hinrichsen, Mullica, Sullivan. House sponsorship Michelson, Jennett and Garcia, Epps, Froelich, McCormick, Titten. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing law. Dashes through the words or numbers indicate deletions from existing law. Health Resources and Services Administration in the United States Department of Health and Human Services to the mandatory preventive healthcare services coverage for health benefit plans. Specifies that the mandatory preventive healthcare services benefit for counseling for, prevention of, and screening for sexually transmitted infection includes HIV prevention drugs and the services necessary for initiation and continued use of an HIV prevention drug, as described in the bill, based on the most recent guidelines and clinical guidance. Requires large employer plans, on and after January 1, 2025, to provide coverage for the total cost of abortion care without policy deductibles, copayments, or coinsurance. Individual and small group plans must provide this coverage if the Federal Department of Health and Human Services confirms the state's determination that the coverage is not subject to state defrayal pursuant to federal law, to the extent required by binding federal jurisprudence. Employers are exempted from providing coverage if providing coverage conflicts with the employer's sincerely held religious beliefs. Section 3 also prohibits a health insurance carrier from requiring a covered person to undergo step therapy or to receive prior authorization before a healthcare provider may prescribe or dispense a medication for the treatment of HIV. Section 4 prohibits a carrier from imposing deductibles, copayments, coinsurance, annual or lifetime maximum benefits, or other cost sharing on coverage for the treatment of a sexually transmitted infection, or sterilization services, which coverage must be provided regardless of the covered person's gender. With the minor's consent, Section 6 allows a healthcare provider acting within the scope of the healthcare provider's license, certificate, or registration to furnish contraceptive procedures, supplies, or information to the minor without notification to or the consent of the minor's parent or parents, legal guardian, or any other person having custody of or decision-making responsibility for the minor. Sections 7 and 8 expand the reproductive health care program administered by the Department of Healthcare Policy and Financing, Department, to include additional family planning services and family planning-related services and allow individuals under 19 years of age to apply for and enroll themselves in the program. Section 9 requires the Department to reimburse licensed healthcare providers for family planning services and -2, 189. Family planning-related services provided to a minor and creates a cash fund from which the General Assembly may appropriate money to the Department for this purpose. Section 10 exempts the cash fund from the limit on uncommitted cash fund reserves. Section 11 requires non-emergency medical transportation services under the State Medical Assistance Program to include expenses for transportation to medical services that are prohibited from coverage pursuant to Section 50 of Article V of the Colorado Constitution. Section 12 of the bill prohibits the use under the State Medical Assistance Program of utilization management, including prior authorization and step therapy, for prescription drugs prescribed for the treatment or prevention of HIV. 1. Be it enacted by the General Assembly of the State of Colorado. 2. Section 1. In Colorado Revised Statutes, 10-16-102, Amend 3, 38.5, as follows, for 10-16-102. Definitions. As used in this Article 16, unless the 5 context otherwise requires. 6, 38.5, HIV infection prevention drug means pre-exposure 7 prophylaxis, post-exposure prophylaxis, or other drugs approved by the 8 FDA for the prevention of HIV infection. 9 Section 2. In Colorado Revised Statutes, 10-16-104, Amend 10, 18, A, I, Introductory Portion, 18, B, X, and 18, B, I, and add 11, 18, B.3, and 26, as follows, 1210-16-104. Mandatory coverage provisions, definitions, 13 rules. 18. Preventive healthcare services. A.I. The following 14 policies and contracts that are issued or renewed in this state must provide 15 coverage for the total cost of the preventive healthcare services specified 16 in subsections 18, B, 18, B.3, and 18, B.7 of this section. 17, B. The coverage required by this subsection, 18, must include 18 preventive healthcare services for the following, in accordance with the 19A or B recommendations of the task force for the particular preventive. 3, 189. 1 healthcare service, 2, X, A, any other preventive services included in the A or B3 recommendation of the task force or required by federal law, any other 4 recommendations established by the ASIP, any other preventive 5 care and screening as provided for in the Comprehensive 6 guidelines supported by the Health Resources and Services 7 Administration of the United States Department of Health and 8 Human Services for Women, and evidence-informed preventive 9 care and screening. Provided for in the Comprehensive Guidelines 10 supported by the Health Resources and Services Administration 11 of the United States Department of Health and Human Services 12 for infants, children, and adolescents. 13, B, this subparagraph, X, subsection, 18, B, X, does not apply 14 to grandfathered health benefit plans. 15, B.3, if counseling, prevention, and screening for a 16 sexually transmitted infection, AS required in subsection. 17, 18, B, 11, of this section, are covered services, the health. 18 benefit plan must provide the coverage without cost sharing, 19 regardless of the covered person's gender, and the coverage 20 must include, consistent with task force requirements, coverage 21 for HIV prevention drugs and services necessary for initiation 22 and continued use of HIV prevention drugs, including Office 23 visits, testing, vaccinations, and monitoring services. 24, E.I. A carrier shall reimburse a pharmacist employed by an 25 in-network pharmacy for prescribing and dispensing HIV infection 26 prevention drugs to a covered person. A carrier shall provide a pharmacist 27 who prescribes and dispenses HIV infection prevention drugs to a 4, 189. 1 covered person pursuant to Section 12-280-125.7 an adequate consultative 2 fee, or, if medical billing is not available, an enhanced dispensing fee, 3 that is equivalent or that is provided to a physician or advanced practice for registered nurse. 5, 26, Abortion care, rules, definition. A. Except as provided 6 IN subsections, 26, D, and 26, G, of this section subject to 7 the provisions of subsections 26, E, and 26, F, of this section, 8 all individual and small group health benefit plans issued or 9 renewed in this state shall provide coverage for the total cost 10 of abortion care. 11, B, the coverage required pursuant to this subsection, 26, 12 IS not subject to policy deductibles, copayments, or coinsurance, 13 except that copayments may apply AS required by a 14 grandfathered health benefit plan. 15, C, the Commissioner shall adopt rules consistent with 16 and as are necessary to implement this subsection, 26. 17, D, an employer is not obligated to provide the coverage. 18 required by this subsection, 26, if, 19, I, providing the coverage conflicts with the 20 employer's sincerely held religious beliefs, or 21, 2, the employer is a public entity prohibited by Section 5022 of Article V of the state constitution from using public funds to 23 pay for induced abortions. 24, E, this subsection, 26, applies to, and the division shall 25 implement the requirements of this subsection, 26, for large 26 employer health benefit plans issued or renewed in this state on 27 or after January 1, 2025. 5, 189. 1F, with respect to individual and small group health 2 benefit plans, 3I, the division shall submit to the Federal Department for Health and Human Services, 5A, the division's determination as to whether the benefit 6 specified in this subsection, 26, is in addition to essential health 7 benefits and would be subject to defrayal by the state pursuant 8 to 42 U.S.C. SEC 18031 D, 3B, and 9B, a request that the Federal Department of Health and 10 Human Services confirm the division's determination within 11 days after receipt of the division's request for confirmation of 12 the determination. 13, 2, this subsection, 26, applies to, and the division shall 14 implement the requirements of this subsection, 26, for 15 individual and small group health benefit plans issued or 16 renewed in this state upon the earlier of, 17, A, 12 months after the Federal Department of 18 Health and Human Services confirms that the coverage specified. 19 in this subsection, 26, does not constitute an additional benefit. 20 that requires defrayal by the state pursuant to 42 U.S.C. SEC 21-18,031 D, 3, B, 22, B, 12 months after the Federal Department of 23 Health and Human Services otherwise informs the division that 24 the coverage in this subsection, 26, does not require state 25 defrayal pursuant to 42 U.S.C. SEC 18031 D, 3, B, or 26, C. The passage of more than 365-27 days since the division submitted ITS determination and request. Dash 6, 189. 1 for confirmation pursuant TO subsection 26 F I of this section. 2 and the Federal Department of Health and Human Services has 3 failed TO respond to the request within that period, in which case for the division shall consider the Federal Department's 5 unreasonable delay a preclusion from requiring defrayal by the 6th state. 7 G. The provisions of this section do not apply to a high 8 deductible health benefit plan pursuant to 26 U.S.C. SEC 223 9 AS amended, issued or renewed in this state until an eligible 10 insured's deductible has been met, unless allowed pursuant to 11 federal law. 12 H AS used in this subsection 26 abortion care has the 13 same meaning AS abortion AS defined in section 25-6-402 1. 14 section 3. In Colorado Revised Statutes, amend 10-16-152 as 15 follows: 1610-16-152. HIV prevention and treatment medication, 17 limitations on carriers, step therapy, prior authorization, study. 18 repeal. 1. A carrier shall not require a covered person to undergo step 19 therapy or to receive prior authorization before a pharmacist may, 20 pursuant to section 12-280-125.7, prescribe and or dispense an HIV 21 infection prevention drug. 22. 2. Before July 1, 2027, a carrier shall not require a 23 covered person to undergo step therapy or to receive prior 24 authorization before a provider may, acting within the 25 provider's scope of practice, prescribe or dispense any drug 26 approved by the FDA and used for the treatment or prevention 27 of HIV that is included on the carrier's prescription drug. Dash 7, 189. 1 formulary as of March 1, 2023. 2, 3, A. The division shall contract with 1 or more 3 entities TO conduct a study that includes qualitative patient 4 and provider experience information and an actuarial review. TO 5 consider the predicted cost and health impacts of removing that 6 requirement for a covered person to undergo step therapy or TO 7 receive prior authorization before a provider may, acting within 8 the provider's scope of practice, prescribe or dispense a drug for 9 the treatment of HIV. In conducting the study, the entity 10 contracted to perform the study must consult with community 11 organizations led by people living with HIV. The division shall 12 provide the completed study to the General Assembly no later 13 than October 1, 2026. 14. B. This subsection, 3, IS repealed, effective July 1, 2027. 15. Section 4. In Colorado Revised Statutes, add 10-16-158 and 1610-16-159 as follows: 1710-16-158. Treatment of sexually transmitted infection, cost. 18. Sharing. 1. If the treatment of a sexually transmitted 19 infection, as defined in section 25-4-402, 10, is a covered service. 20 The health benefit plan must provide the coverage without 21 deductibles, copayments, coinsurance, annual or lifetime. 22 maximum benefit limits or other cost sharing for or limits on. 23 The coverage for the treatment of a sexually transmitted 24 infection. 25. 2. The provisions of this section do not apply to a high 26 deductible health benefit plan pursuant to 26 U.S.C. SEC 223-27 as amended, issued or renewed in this state until ineligible. Dash 8, 189. 1 insured's deductible has been met, unless allowed pursuant to 2 federal law. 310-16-159. Coverage for sterilization services, cost sharing. 4. 1. If sterilization services are a covered service, the Health 5 benefit plan must provide the coverage regardless of the 6 covered person's sex or gender and without deductibles, 7 copayments, coinsurance, annual or lifetime maximum benefit 8 limits, or other cost sharing for or limits on the coverage for 9 sterilization services. 10. 2. The provisions of this section do not apply to a high 11 deductible health benefit plan pursuant to 26 U.S.C. SEC 223-12 as amended, issued or renewed in this state until an eligible 13 insured's deductible has been met, unless allowed pursuant to 14 federal law. 15. Section 5. In Colorado Revised Statutes, 12-280-125.7, 16 amend, 1, introductory portion, 1, C, 2, 3, introductory portion, 17, 5, A, and 5, B, as follows: 1812-280-125.7. Pharmacist's authority to prescribe and 19. Dispense HIV prevention drugs, definitions, rules. 1. As used in this 20 section, unless the context otherwise requires. 21. C. HIV infection prevention drug means pre-exposure. 22. Prophylaxis, post-exposure prophylaxis, or other drugs approved by the 23 FDA for the prevention of HIV infection. 24. 2. A pharmacist may prescribe and dispense HIV infection 25 prevention drugs in accordance with a standing order pursuant to section 2625-1-130 or a statewide drug therapy protocol developed pursuant to 27 subsection 5 of this section. Dash 9, 189. 1. 3. Before prescribing or dispensing HIV infection prevention 2 drugs to a patient, a pharmacist must 3.5a. On or before 6 months after July 13, 2020, the State Board 4 of Pharmacy, the Colorado Medical Board, and the State Board of Nursing 5 shall, in collaboration with the Department of Public Health and 6 Environment, and as described in Section 12-280-601(1)(b), develop 7 statewide drug therapy protocols for pharmacists to prescribe and 8 dispense HIV infection prevention drugs. 9b. If the State Board of Pharmacy, the Colorado Medical Board, 10 and the State Board of Nursing are not able to agree in the time period 11 required by subsection 5a of this section to statewide drug therapy 12 protocols for pharmacists to prescribe and dispense HIV infection 13 prevention drugs, the State Board of Pharmacy shall collaborate with the 14 Department of Public Health and Environment to develop and implement 15 statewide drug therapy protocols by January 1, 2021. 16 Section 6. In Colorado Revised Statutes, amend 13-22-105 as 17 follows, 1813-22-105. Minors, consent, contraception. Birth control 19 with the minor's consent, a healthcare provider licensed, 20 certified, or registered pursuant to Title 12 who is acting within 21 the healthcare provider's scope of practice may furnish 22 contraceptive procedures, supplies, and or information may be 23 furnished by physicians licensed under Article 240 of Title 12 to any A24 minor who is pregnant, or a parent, or married, or who has the consent of 25 the minor's parent or legal guardian, or who has been referred for such 26 services by another physician, a member of the clergy, a family planning 27 clinic, a school or institution of higher education, or any agency or 10-189. 1 instrumentality of this state or any subdivision thereof, or who requests 2 and is in need of birth control procedures, supplies, or information 3 without notification 2 or the consent of the minor's parent or 4 parents, legal guardian, or any other person having custody of 5 or decision-making responsibility for the minor. 6 Section 7. In Colorado Revised Statutes, 25.5-2-103, amend 7, 2, 6, and 7, C, repeal 1A, and add 1G, and 5.5, as follows, 825.5-2-103. Reproductive Health Care Program, Report, Rules 9, Definitions. 1. As used in this section, unless the context otherwise 10 requires. 11a. Contraceptive methods and counseling services, means. 12i. Any FDA-approved contraceptive drug, device, or product. 13.2. Services related to the administration and monitoring of 14 FDA-approved contraceptive drugs, devices, and products, including 15 management of side effects. 16.3. Counseling services for continued adherence to a prescribed 17 regimen. 18.4. Device insertion and removal, and 19.v. Any other contraceptive methods and counseling services 20 identified by the Health Resources and Services Administration in the 21 United States Department of Health and Human Services or the Women's 22 Preventive Services Guidelines as of December 17, 2019. 23.g. Reproductive Healthcare Services, means Family 24 Planning Services, as defined in Section 25.5-4-412, 2b, and 25 Family Planning Related Services, as defined in Section 25.5-4-412, 26, 2a. 27, 2, on and after July 1, 2022, the State Department shall 11-189. 1. Administer a reproductive health care program, referred to in this section 2 as the program, that provides contraceptive methods and counseling. 3. Reproductive health care services to participants. 5.5, to the extent practicable, the State Department 6 shall ensure that eligible individuals seeking to participate in 7. The program are able to apply for and enroll in the program 8 through their local county office, a state medical assistance 9 program site, an online application, or any other mechanism that 10 is available to applicants for the state medical assistance 11 program. 12.6. The State Department shall provide contraceptive methods and 13 counseling reproductive health care services to participants without 14 imposing any cost-sharing requirements. 15.7. Beginning in state fiscal year 2023 to 24, the State Department 16 shall analyze and report the cost-effectiveness of the program to the 17 public through the annual hearing, pursuant to the State Measurement 4. 18. Accountable, responsive, and transparent, smart, Government Act, 19 Part 2 of Article 7 of Title 2. At a minimum, the report must include 20c. The cost of providing contraceptive methods and counseling. 21. Reproductive health care services to participants, 22 Section 8. In Colorado Revised Statutes, 25.5-1-201, amend 23.1, introductory portion and 1, f.5, as follows, 24.25.5-1-201. Programs to be administered by the Department 25 of Healthcare Policy and Financing. 1. The Department of Healthcare 26 Policy and Financing State Department shall administer the following 27 programs and perform the following functions. 12.189. 1. F.5. The Reproductive Health Care Program that provides 2 contraceptive methods and counseling. Reproductive health care 3 services, as specified in Section 25.5-2-103, 45 Section 9. In Colorado Revised Statutes, add 25.5-5-514 as 6 follows, 725.5-5-514. Prescription drugs used for treatment or 8 prevention of HIV, prohibition on utilization management, 9 definition. 1. As used in this section, HIV means human 10 immunodeficiency virus. 11.2a. Before July 1, 2027, the State Department shall not 12 restrict by prior authorization or step therapy requirements 13 any prescription drug approved by the Federal Food and Drug 14 Administration that is used for the treatment or prevention of 15 HIV if a prescribing practitioner licensed pursuant TO Title 12-16 has determined the prescription drug TO be medically necessary 17 for the treatment or prevention of HIV for a recipient. 18 prescription drugs used for the treatment or prevention of HIV. 19 include protease inhibitors, non-nucleoside reverse. 20 transcriptase inhibitors, nucleoside reverse transcriptase 21 inhibitors, antivirals, integrase inhibitors, long-acting 22 medications, and fusion inhibitors. 23b. Nothing in this subsection, 2, prevents the State 24 Department from performing drug utilization review that may 25th be necessary for patient safety or for ensuring the prescribed 26 use is for a medically accepted indication, as required by Section 27-1927 of the Social Security ACT of 1935. 13-189. 1 Section 10. In Colorado Revised Statutes, 25-6-101, amend 2-1, as follows, 325-6-101. Legislative Declaration. 1. Continuing population for growth either causes or aggravates many social, economic, and 5 environmental problems, both in this state and in the nation. Every 6 individual has a fundamental right to make decisions about the 7 individuals' reproductive health care, including the 8 fundamental right to use or refuse contraception. 9 Section 11. In Colorado Revised Statutes, add 25-6-104 as 10 follows, 1125-6-104. Department of Public Health and Environment, 12 Family Planning Access Collaborative, Legislative Declaration, 13 Recommendations, Funding. 1a. The General Assembly finds and 14 declares that, according to a 2019 report by the Colorado 15 Department of Public Health and Environment, referred to in the 16 Section AS the Department, in 2019, there were 17,300 Coloradans without access to family 18 planning services, including 58,000 Coloradans. 19 who were uninsured and 35,320 who were insured, but not using their family planning coverage. 21 primarily due to fear of breaches in confidentiality. 22b. The General Assembly further finds that there have 23 since been important expansions in access, including a State Plan 24 Amendment TO expand income eligibility for services, the 25 creation of coverage programs for undocumented individuals, 26 expansions of commercial and Medicaid insurance coverage, and 27 increased family planning funding. However, persistent gaps in 14-189. 1 access remain. 2. The Department shall convene a Family Planning 3 Access Collaborative to coordinate with the Department TO for advise the Department in identifying access gaps that contribute 5 to approximately 93,000 Coloradans lacking 6 family planning access, including, but not limited to, 7a. Privacy and confidentiality concerns, 8b. Gaps in existing family planning programs, 9c. Geographic barriers and rural access, 10d. Ability of adolescents to access care and services. 11e. Funding for services. 12f. Identification of legislative, regulatory, and funding. 13 strategies to close access gaps identified by the collaborative. 14.3. The Department shall invite representatives with 15 relevant expertise in the provision of, funding of, and advocacy 16 for family planning services to participate in the collaborative. 17.4. The Department shall convene the Family Planning 18 Access Collaborative on or before September 1, 2023. 19.5. On or before December 15, 2023, the collaborative. 20 shall publish recommend.
Representative Bottoms.
I would like to request to pause the recording. Pause the reading of the bill at length.
Can you request to withdraw the motion to have the bill read at length? Withdraw the request.
I just want to pause it because we may want to read it again depending on what happens.
Well, if we,
Finish reading.
okay, we will pause the reading of the bill.
Yeah, I request to pause the reading of the bill at length.
Thank you. The reading will be paused. Is there any further discussion? Representative Bottoms.
So a couple of things. One is I did want to make sure that this got heard and it was understood. My wife and I dealt with the exact same thing that was mentioned earlier. By the sponsor of the bill, we lost one of our children. It was a miscarriage in late in term. And we went to the doctor and found out that obviously the baby now is not living, and they said some of the same things, that this is septic. But it was mentioned earlier that this is called an abortion when the baby is removed. That is not true. It's called a D&C, and this is what the doctor told us, and it's done at hospitals. It's a very common thing. You don't have to go to some type of abortion clinic or anything like that. It's called a dilation and cooterage. It's done under general anesthetic, and the procedure will remove any pregnancy tissue from the uterus. It is successful in 95 to 100% of cases, but there are small surgical risks. So the idea that any abortion bill under any circumstance in any state in the United States deals with this and calls it an abortion is not true. This is immediate medical attention that every single person that goes in with this gets that medical attention the exact same way, because it will become septic. And so this is not an abortion. It's never been called an abortion. It's actually in the books as a DNC, and I know that because my wife and I had one of those between our second and fourth child. And with that, I would like to move Amendment L040 and have it properly displayed. You guys want one?
Thank you. The amendment has been moved, but I'll take a moment. Okay, the amendment has been moved and properly displayed to the amendment. Representative Bottoms.
Okay, this deals with the health benefit plans of this. And you can see where it says page 5, line 24, and then page 5, line 27. I would like to insert, notwithstanding subsection 26EI, Roman number 1 of this section, for large employer health benefit plans. The coverage provided pursuant to this section does not apply to an elective abortion by a covered person. We've been talking about, and the bill sponsor have mentioned driving up the cost of this. This would greatly reduce the cost. I mean, enormously remove the cost, reduce the cost when it comes to the employer health benefit, the large employer health benefit plans. And so I urge an aye vote on Amendment 040.
Representative Michelson-Janae.
Thank you, Madam Chair. I urge a no vote on this, and I also urge a no vote on calling me a liar at the well.
We will honor such requests on both sides. Thank you for bringing it to our attention. Also, we want to be sure that you can let me know of your concerns so that we can handle it here from the dais. Sorry. The question before, I'm sorry, is there any further discussion on the amendment? Representative DeGraff.
Thank you, Madam Chair. This is interesting because the previous bill, by the use of medication being for an injury or illness, really kind of classifies pregnancy as an illness or injury. And we know that over 99% of pregnancies or that for elective abortion are they're just used as normal birth control or the result of lack of birth control or lack of self-care, or whatever you want to do. But either way, the pregnancy as an injury or illness, in this case, is self-inflicted. And I don't think there's any coverage that covers self-inflicted injury or illness. So, I don't know, just by the nature of how that medication is now being used for injury or illness, making pregnancy an injury or illness. Now you want health care plans to cover a self-induced illness or injury. So I have absolutely no doubt you're going to disagree with that, but I am curious on the statistics. The statistics that we have, or that I've seen, or that have been collected, like Florida, out of 80,000 elective feticides performed, less than 0.5% were for anything other than self-inflicted. So if it's self-inflicted, then why should an insurance coverage have to pay for it? why should all of the other members be forced to pay for a self-inflicted injury?
Representative Froelich.
Thank you, Madam Chair. The idea that this terminology that has been developed to discuss a private medical decision has even entered our lexicon is disheartening.
Go to Representative Wilford and then Representative DeGraff.
Thank you, Madam Chair. I'm not up here to filibuster, I'm up here to share a very personal story.
If it's within the realm of the amendment.
It absolutely is, Madam Chair.
Thank you.
I was 17 years old, living in Laramie, Wyoming, when I was sexually assaulted. And yes, please stand up, because if that means that you hear me and you hear my words, then I encourage you to stand up. I'm not going to share the details, because nearly 20 years later, I am not ready to share them, and frankly, it's nobody else's business but mine. I wasn't old enough at the time to buy Plan B, and it wasn't available over the counter for me either. And I will tell you that I've never felt more relieved than when my period came and I knew I wasn't pregnant. But under an amendment like this, I would not be able to seek abortion care after being sexually assaulted, and that is not okay in Colorado. In Colorado, we allow people and pregnant women to make their choices about their bodies in consultation with their doctors, their family members, their faith, clergy, whoever they want to consult with. My sexual assault and a need for an abortion is not a self-inflicted situation. So let's strike that language from our lexicon, because it is not respective of women and pregnant people, and we are not doing that here in Colorado today. I ask for a no vote on this amendment.
Representative DeGraff, but before you speak, I'd like to note what the requests have been. We will certainly allow people to be able to talk to their beliefs, but we'd ask that we can at least consider and hear what the requests have been. Representative DeGraff.
Absolutely, Madam Chair. I definitely respect you. I respect my colleague, and I did leave the carve out for that, in that I said it was 99.5 or over 99.5, and I do respect that women are allowed to make their own choices. And in this case, what was shared with us was an egregious example of somebody not being able to make their own choice, and that does admittedly create an entirely different problem, because that autonomy was taken away from our colleague, and that is absolutely wrong, and I agree with that 100%. That bodily autonomy that was removed, that was taken, whether you want to consider that a property, whether you want to consider a self-property, life is considered your first property, I 100% agree. But my point was the 99.5 that doesn't apply to. Now we have an amendment, and we could include a carve-out for it, or somebody could amend the amendment. But the fact remains, my point was the definition that we've now changed this to makes pregnancy an illness or injury, and now we want to take that, and we want that, because it is a very personal choice, it is a very individual choice, and I get that 100%, that it is an individual's choice in what they do. But typically, when we make choices, we don't then pass on the burden of those choices to somebody else. That's it. We don't pass on the burden of our own personal choices. Now, my colleague didn't have a choice. That was removed. And I would say that is there's another issue there that we need to cover, and that would be the whole soft on crime issue where people that do that are released. But what we are talking about here, and if you want to amend the amendment, but what we're talking about is the 99.9 or 99.5% of these cases where they are the result of an individual choice. And it's an individual choice, and it's an individual responsibility. That's all this is saying. This is not a condemnation of my colleague. We are trying to have a full-up discussion here. I'm sorry if there is absolutely no intent to hurt any feelings. We cannot have this podium be something where we can't have this where speech is restricted. Yes, this is a very uncomfortable topic, 100% uncomfortable topic. But we can't not talk about it. We can't say we're not talking about it because it's uncomfortable. So I would like to know why, with a 99.5% of the people, that responsibility is conferred onto an entire other program. That's all I want to know. What other things are we going to have where people's like any other program, if you want to go hang gliding, you are going to get a special insurance for that, and that is going to cover you. Otherwise, you're not going to be covered. It's an example.
It's okay.
You engage in activities, and you pay a different premium for it. That's all I'm saying. We're taking this special thing where we're saying there's nobody, because what you don't want to do is you don't want to create where somebody has a vested interest in what you do in the privacy of your own home, and an insurance program that is forced to cover everything like this all of a sudden has a vested interest in what you do, and it removes your privacy. So this is going to drive up costs. I'm happy to, not happy, it's uncomfortable either way, but we can't have a broad, what I'm talking about is when people, two consenting adults, make a choice, what is the justification for that choice resulting in A, an unborn human not having a choice, an unborn person not having a choice, not having First, Fifth, Sixth, 14th, 8th Amendment rights, that we justify that, and then we take the 14th Amendment rights and the 5th Amendment rights of having your property removed without due process in order to cover that.
Representative DeGraff, thank you for trying to navigate the space. I just want to put back in front of us the question on the amendment is around elective abortion by a covered person, and if we can stay within that space. I will call Representative Garcia.
Members, I just want to reiterate that elective abortion is not a medical term. It does not exist within the medical field. Therefore, we cannot create something new without consulting with the medical people, I guess, if you will. So I urge a no vote.
Representative DeGraff, to the amendment.
Elective abortion is a term. There's elective abortion, spontaneous abortion. Generally, abortion, looking it up, it is a medical term in and of itself. Elective specifies that it is elective. It is not medically required.
The question before us is the passage of Amendment L40. Is there any further discussion? Seeing none, all those in favor, please say aye. Aye. All those opposed say no. No. The amendment fails to the bill. Representative Evans.
Thank you, Madam Chair. So we've discussed at length earlier how healthcare, reproductive healthcare providers are a major intersection point for folks that are seeking care and have also been victims. And so in accordance with some of the earlier things that I talked about, particularly starting with that White House document and then running down through a list of other data and resources that I had mentioned, I move Amendment L043 and ask that it be displayed.
It's a proper motion. We'll get it displayed if you give us a moment. Thank you. To the amendment, Representative Evans.
Thank you, Madam Chair. So 2 paragraphs here. The first paragraph here just refers back to the reproductive health care worker that's defined earlier in the bill. And then the second paragraph here just states that reproductive health care workers need to make sure that they're aware and following those mandatory reporting requirements for child abuse and neglect as are already established in the law. This is an important amendment because what this does is this just ensures that if somebody comes seeking reproductive health care and they are the victims of a broader set of circumstances, that we can actually get resources to treat the root of that issue and make sure that we're providing the holistic health care to which our community members are entitled. And so for those reasons, I would ask for an aye vote on Amendment L043.
Is there any further discussion on Amendment L43? Representative Michelson-Janae.
Thank you, members. I ask for a no vote on L43.
The question before us is the passage of Amendment L43. Seeing no further discussion, all those in favor, please say aye. Aye. All opposed, please say no. No! The amendment fails. To the bill. Representative Evans.
Thank you, Madam Chair. Same conversation that we've had before. There's a big intersection point per that White House document that talks about combating human trafficking with healthcare providers. So with that in mind, I move Amendment L045 and ask that it be displayed.
Sorry, y'all. Amendment L45 has been properly moved and displayed. To the amendment, Representative Evans.
Thank you, Madam Chair. So same portion of the bill, the portion of the bill where it's talking about the authority of the commissioner to promulgate rules. This is just saying that in accordance with that Biden White House document, that healthcare and reproductive healthcare workers are critical partners that are engaged in the fight against human trafficking because of the major intersection with healthcare providers and human trafficking victims. And so that reproductive health care workers should receive training on being able to recognize and properly report instances of human trafficking. I ask for an aye vote on Amendment L045.
Representative Garcia.
Members, this amendment is just not necessary. Healthcare workers across the board are already trained in identifying this. Let's not waste more trees by adding more pages to statute books. I urge a no vote.
Is there any further discussion on Amendment L45? Seeing none, the question before us is the passage of Amendment L45. All those in favor, please say aye. Aye. All those opposed, please say no. No! The amendment fails. To the bill, Representative Evans, welcome back.
Thank you, Madam Chair. Same concept. We've talked about it at length. The additional data point that I'll add is I had a reproductive health care facility in the jurisdiction where I was a law enforcement officer for 10 years. I received numerous reports from every other health care provider in that district, in that jurisdiction, and also from all of the surrounding health care entities. The reproductive health care center that was in my jurisdiction, I cannot ever remember receiving a report from them. So just want to make sure that we are having a holistic approach that covers all healthcare workers and ensures that they get this vital training. So with that in mind, I move Amendment L046 and ask that it be displayed.
L46 has been properly moved and displayed. To the amendment. Representative Evans.
Thank you, Madam Chair. Again, same part of the bill, authority of the commissioner to promulgate these rules. This is just talking about domestic violence awareness training that should be provided to those reproductive health care workers based on the fact that there is that high degree of probability that they are interacting with folks who have been the victims of domestic violence. I've read you the data from USA today. I've read you the data from a variety of other sources, to include sources affiliated with Planned Parenthood. I've read you the data from the White House itself. So with that in mind, ensuring that our community members are getting the holistic care to take care of the broader set of circumstances in which they may find themselves, I ask for an aye vote on L046 to ensure that reproductive health care workers are receiving domestic violence awareness training and able to make the appropriate referrals. Thank you.
Representative Garcia.
Thank you. Madam Chair, I call it, just kidding. I'm sorry, it's late. I just want to reiterate again that this is a training that healthcare providers and healthcare workers, also receptionists, also undergo as a mandatory part of their training. We don't need to continue bringing these amendments that are unnecessary. I strongly urge a very loud no vote.
Is there any further discussion? Seeing none, the question before us is the passage of Amendment L46. All those in favor, please say aye. Aye. All those opposed, please say no. No! Cuidado, the amendment fails. To the bill, Representative Evans. I corrected myself.
Some say 3 times a
Kind
charm,
sir.
I say 4th time's a charm.
Sorry, Representative Evans, go ahead.
Thank you, Madam Chair. I say 4th time's a charm here. So the last situation, again, this is based on over 10 years of my personal experience working in law enforcement, investigating, responding to, and coordinating with all of these different situations. I'm speaking to personal experience here. I'm speaking to the fact that the White House itself is talking about increasing the training and synchronizing a holistic approach to ensure our community members are getting the care that they need. So we've talked about domestic violence, trafficking, mandatory reporting. I move Amendment L044 and ask that it be displayed.
L044 has been moved and properly displayed to the amendment. Representative Evans.
Thank you, Madam Chair. Again, same part of the bill here. This is just saying that reproductive health care workers shall receive child abuse awareness training. This is critically important, as we've discussed with this bill, talking about minors receiving this care. We need to make sure that our healthcare workers, reproductive workers, are receiving this training so that they can identify and appropriately respond to instances of child abuse, so that somebody who is being victimized as a result of a broader set of life circumstances doesn't have just the symptom of that abuse treated without having appropriate referrals made out to address the underlying cause of this. So I ask for an aye vote on Amendment L044.
Representative Garcia.
Thank you, Madam Chair. I want to just thank the good representative from Adams County for bringing these amendments to demonstrate how much he truly cares about women, children, victims of domestic violence. And I want to urge you a no vote because, again, healthcare workers already receive this training and are mandatory reporters. And again, I urge another no vote. Thank you.
Is there any further discussion on Amendment L44? Seeing none, the question before us is its passage. All those in favor, please say aye. Aye. All those opposed, please say no. No. The amendment fails. To the bill, Representative DeGraff.
Thank you, Madam Speaker.
Madam Chair.
Sorry, it's late. That covers
Thank you.
a lot. All right. 13-22-702, the people of the state of Colorado, pursuant to the powers reserved in them in Article 5 of the Constitution of the state of Colorado, declare that family life and the preservation of the traditional family unit are of vital importance to the continuation of an orderly society, that the rights of parents to rear and nurture their children during their formative years and to be involved, and I think that's formative years, that would be like being a minor, I think, should be involved in all decisions of importance affecting such minor children should be protected and encouraged, especially as such parental involvement relates to the pregnancy of an unemancipated minor. Emancipation is an option, recognizing that the decision by any such minor to submit to an abortion may have adverse long-term consequences for her. The people of the state of Colorado, being mindful of the limitations imposed by them at the present time of the federal judiciary and the preservation of the parent-child relationship, hereby enact the following provisions. A medical procedure necessary to prevent the pregnant minor's death, for which delay would create serious risk of substantial and irreversible impairment relative of the minor, means the minor's grandparents, aunt, uncle, etc. And then it gets into some other definitions that we don't really need right now. So in order to keep with 13-22-702, I'd like to go to Section 6, page 10, lines 18 through 27, and then on page 11, 1 through 5, because this ultimately, and as the representative mentioned, that it really does not, but what it does is it allows birth control to be granted to a minor with the minor's consent, and that is in violation of 13-22-702, which was afterwards, so this was afterwards, so this would be the more recent, that the people of Colorado, pursuant to the powers reserved in them in Article 5 of the Constitution, declare that the family life and preservation of traditional family are of vital importance to the continuation of an orderly society, that the rights of parents to rear and nurture their children during the formative years be involved in all decisions. So since 13-22-105 violates 13-22-702, I would like to move L050 to SB 189 and ask that it be displayed.
Thank you. Sorry, we're just getting it displayed. There we go. The amendment has been properly moved and displayed. To the amendment, Representative DeGraff.
Thank you, Madam Chair. Page 10 strikes lines 19 through 27. Substitute procedures, supplies, information may be furnished by physicians licensed under Article 240 of Title 12 to any minor who is pregnant or a parent or married or who has a consent of the minor's parent. So what that does, what that paragraph does, and even though it was modified, is it cuts parents out of all the part that it says all decisions that of importance, and I would say those are important decisions of such minor children that should be protected. So it takes the language that allows, in this case, minor children to undergo procedures, not just receive medication that may or may not be actually approved, and nobody discussing that with them in all decisions of importance, which that would be pretty important, and medical procedures involving their medical health. So since 13-22-702 requires that parents be involved in these decisions, and that is violated, I recommend an aye vote on this, and let's have some, we'll clean up our CRS.
Thank you. Representative Garcia.
Members, I urge a no vote.
Is there any further discussion on Amendment L50? Seeing none. The question before us is the passage of Amendment L50. All those in favor, please say aye. Aye! All those opposed, please say no. No! Okay. The amendment fails. To the bill. Representative Holtorf.
Thank you, Madam Chair. We sit here having very difficult discussions about very difficult subjects. the issue of what insurance companies should cover, what co-pays or deductibles should apply. I do want to point out something that I want my colleagues and the prime sponsors to understand about this legislation is that in the insurance world, oftentimes when you have an insurance policy that is a policy that you have to buy yourself, when you do have a copay limit that you want to meet, sometimes you want that number to be reached. Let's say it's $5,000 or $10,000 copay, which is pretty common. That if you do things in the medical care that's given within the scope of your family, if you don't allow for that charge, you don't get to that point. And then what happens is other things cost you money because you don't get that credit. That's an unintended consequence of this legislation. That also will affect the financial situation of Colorado families. That's a consideration. But I do have a letter from a constituent, and I do want to read it, because I want people to know some of the objections from the people that I represent. In this particular letter, it says, I disagree with the provision in this bill that large employer insurance plans be required to cover all three specific types of care: abortion services, treatment of sexually transmitted infections, and sterilization procedures. 100% without policy deductibles, co-pays, or co-insurance. And I also feel that way. There are certain things, and there should be care offered in certain situations where perhaps there is none of those. But as routine care goes, or even, routine care, let's say a vasectomy, it's a sterilization procedure. Without policy deduction, co-pays, or co-insurance. I don't understand why these three types of procedures should receive special treatment above all other procedures. And this is a fair question. And my colleague from Grand Junction pointed out some issues that he had with respect to in a large corporation under certain policy provisions, that there could be liability issues if one thing was covered and another thing wasn't covered, and that could cause litigation that could hurt his company. Let's remember that there's other people out there, and these things affect them. Now, this particular constituent says, I don't believe it is the place of the state government to require insurance plans to totally cover all these specific areas of treatment. And this constituent shares my concerns. This person says, I'm concerned about the potential ripple effects financially for companies that require to provide this coverage. Now, this goes right down the line of discussion that probably one of the most experienced and learned colleagues that I have in my caucus with respect to business. Not only is he an adjunct professor, but he's ran a multinational company. That is an incredible life achievement. And when those kind of incredible people speak up, we need to listen and accommodate and try to build and find solutions in those instances. And we haven't done that tonight, I don't think. We haven't done well in that regard, and I'm disappointed about that. Because I'm always here advocating for compromise and working together and trying to find solutions. and find the middle. Find solutions that run down the middle with compromise that solve the problems that we all share and take everybody's perspectives at heart and under rigorous and scrutinous consideration. Now I'm going to finish this up. This letter isn't very long. It's only one page. In addition, this person says, I'm greatly concerned about the section of the bill that requires healthcare providers to provide contraception procedure supplies or information to a minor without notifying or receiving consent of the minor's parent. In an official capacity, I'm always on the side of parents trying to help parents in their difficult job of raising their children. But I also know that a lot of times minors don't want to go talk to their parents because of these complicated issues, and that is a reality. And there should be a way for them to get some counseling and get some resources. So I do understand that. This provision undermines the authority of parents who are legally or morally responsible for the well-being of their children by removing them from the decision-making process. Parents have every right to know and decide what is best for their children who are not yet old enough to make these kinds of decisions for themselves. We've been talking about that for the last 2 days, ladies and gentlemen. If a parent believes that the underage child is not yet mature enough to receive information about contraception, medical providers shouldn't be allowed to go behind their parents' backs to give the information to their children without the parents' knowledge. Now, I wish we could find common ground. I wish we could work together to find common ground in these very challenging issues. I would argue that that common ground needs to be solicited and worked out in committee to the best of our abilities. And if we do that, I think on second readings and what we do here at these times will be streamlined and be so much more efficient. So, I just want everybody to know that I have serious reservations about this bill. I believe that we have not worked together well on all of these bills. And for that, I think we need to try to find a way to do better for all of Colorado. Thank you.
Thank you. Representative Soper.
Thank you, Madam Chair. I move Amendment L051 and ask that it be properly displayed.
L051 has been properly moved and displayed. To the amendment, Representative Soper.
Thank you, Madam Chair. This continues the conversation we had earlier. It addresses the concerns that were also raised earlier, and I would ask for a yes vote.
Representative Michelson-Janae.
Thank you, Madam Chair. I ask for a no vote.
The question before, sorry. Is there any further discussion? Seeing none, the question before us is the passage of Amendment L51. All those in favor, please say aye. Aye. All those opposed, please say no. No! The amendment fails. To the bill. Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 189 as amended. All those in favor, please say aye. All those opposed, please say no. No! The bill passes. Thank you, colleagues. Madam Majority Leader?
Thank you, Madam Chair. I move to rise and report.
I have not moved on the motion, but thought I have some commentary about how we yell in the chamber, but I'll go ahead and rise and report. Thank you, everyone. The committee will rise and report.
The House will come to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. Senate Bill 189 is amended, passed on second reading in order to revise and place on the calendar for third reading and final passage.
Who am I calling on? Ah, there she is. Assistant Majority Leader Bacon. Members, you have heard the motion. There are amendments at the desk. Mr. Shebel, please read the Bottoms amendment to the Committee of the Whole report.
Representative Bottoms moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Bottoms Amendment L40 to Senate Bill 189 to show that said amendment did pass and that Senate Bill 189 is amended passed.
Representative Bottoms.
I'd like to move the amendment to the report of the Committee of the Whole and see it on the screen, however I normally say
It
that.
is properly displayed.
And again, I want to read it, notwithstanding subsection 26EI of this section for large employer health benefit plans. This is trying to, again, to lower these costs back down. This bill is going to raise costs astronomically, and so try to pull this back a little bit. The coverage provided pursuant to this section does not apply to an elective abortion by a covered person. So I would urge an aye vote on this.
Seeing no further discussion, the question before us is the adoption of the Bottoms Amendment to the Committee of the Whole report. Mr. Shebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Representative Story. Representative Herod is excused. Please close the machine. With 18 aye, 42 no, and 5 excused, the amendment is lost. Mr. Shebel, please read the DeGraff amendment to the Committee of the Whole report.
Representative DeGraff moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following DeGraff Amendment L50 to Senate Bill 189 to show that said amendment passed and that Senate Bill 189 is amended passed.
Representative DeGraff.
Thank you, Madam Speaker. I move for the adoption of L050 amended to the Committee of the Whole report and ask that it be displayed.
It is properly displayed. Please proceed.
Thank you. I move to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following amendment L050 to SB 23-189 to show that the amendment passed and that SB 23-189 as amended passed. Ma'am, may I grab a piece of paper off my desk as the justification?
Sure.
Thank you.
Please proceed.
Thank you, ma'am. All right, colleagues, this was in part, I think it's an oversight. The people of the state, in accordance with 13-22-702, because the language that is in the bill, bill currently is it's in contradiction of this part. And that part is the people of the state of Colorado, pursuant to the powers reserved to them in Article 5 of the Constitution of the State of Colorado, declare that the family life and the preservation of the traditional family unit are of vital importance to the continuation of an orderly society, that the rights of parents to rear and nurture their children during the formative years, so while they're minors, less than 18, and be involved in all decisions of importance affecting such minor children should be protected and encouraged, especially if such parental involvement relates to the pregnancy of an unemancipated minor, recognizing that the decision by any such minor to submit to an abortion may have adverse long-term consequences for her. So, Preservation of the family unit, considered by Colorado to be, in the past anyways, used to be of vital importance. If we want to continue that all parents will be involved in all decisions of importance affecting such minor children. And I think we could all agree that birth control and the need for birth control and the being subjected to medical procedures would be a decision of importance affecting an emancipated minor. So for sanity, I would like to request an aye vote, and for support of the family unit especially, I would like to request an aye vote on this amendment.
Seeing no further discussion, the question before us is the adoption of the DeGraff Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 18 aye, 42 no, and 5 excused, the amendment is lost. Mr. Schiebel, please read the first Evans Amendment to the Committee of the Whole report.
Representative Evans moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Evans Amendment, L43, to Senate Bill 189, to show that said amendment passed and that Senate Bill 189 is amended passed.
Representative Evans.
Thank you, Madam Speaker. I move the first Evans Amendment to the report of the Committee of the Whole and ask that it be displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. As we discussed before, I think it's vitally important that reproductive health care workers get training on child abuse, recognizing child abuse, and having the appropriate skill set to make the necessary referrals to address the core issue that may be causing somebody to seek that health care. I ask for an aye vote on this amendment.
Seeing no further discussion, the question before us is the adoption of the first Evans Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 18 aye, 42 no, and 5 excused, the amendment is lost. Mr. Schiebel, please read the second Evans Amendment to the Committee of the Whole report.
Representative Evans moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Evans Amendment, L44, to Senate Bill 189, to show that said amendment passed and that Senate Bill 189 is amended passed.
Representative Evans.
Thank you, Madam Speaker. I move the second Evans Amendment to the report of the Committee of the Whole and ask that it be displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. As we discussed, it's important that reproductive health care workers receive training on child abuse awareness, and so I ask for an aye vote on this amendment.
Seeing no further discussion, the question before us is the adoption of the second Evans Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 18 aye, 42 no, and 5 excused, the second Evans Amendment is lost. Mr. Schiebel, please read the third Evans Amendment to the Committee of the Whole report.
Representative Evans moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Evans Amendment, L45, to Senate Bill 189, to show that said amendment passed and that Senate Bill 189 is amended passed.
Representative Evans.
Thank you, Madam Speaker. I move the third Evans Amendment to the report of the Committee of the Whole and ask that it be displayed.
It is displayed. Please proceed.
Thank you, Madam Speaker. This is taken directly from the Biden White House directive on the national strategy to combat human trafficking. Don't vote against the White House.
Seeing no further discussion, the question before us is the adoption of the third Evans Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 19 aye, 41 no, and 5 excused, the third Evans Amendment is lost. Mr. Schiebel, please read the fourth Evans Amendment to the Committee of the Whole report.
Representative Evans moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Evans Amendment, L46 to Senate Bill 189, to show that said amendment passed and that Senate Bill 189 is amended passed.
Representative Evans.
Thank you, Madam Speaker. I move the fourth Evans Amendment to the report of the Committee of the Whole and ask that it be displayed.
It is properly displayed. Please proceed.
I apologize for having my amendments in the wrong order. I can't top the last one. Vote yes.
Thank you, Representative Evans. Seeing no further discussion, the question before us is the adoption of the fourth Evans Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Representatives Valdez and Young. Thank you. Please close the machine. With 18 aye, 42 no, and 5 excused, the fourth Evans Amendment is lost. Mr. Schiebel, please read the Soper Amendment to the Committee of the Whole report.
Representative Soper moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Soper Amendment, L51 to Senate Bill 189, to show that said amendment passed and that Senate Bill 189 is amended passed.
Representative Soper.
Thank you, Madam Speaker. I move the Soper Amendment to the Committee of the Whole report and ask that it be properly displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. So this amendment says the coverage for abortion care must include the availability of at least one post-abortive counseling session for the covered person without increasing premiums for the coverage. This addresses the concerns that were stated earlier, that we believe in mental health in Colorado, and we believe that certainly insurance must cover this. It's not a mandate on the patient. It's not a mandate on the covered person. What it's saying is that insurance must allow this so that if the covered person says, you know, I would like to have some mental health here, mental health counseling, that would be covered and that it would be still part of the abortion care that's here without increasing premiums. Thank you.
Seeing no further discussion, the question before us is the adoption of the Soper Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 17 aye, 43 no, and 5 excused, the Soper Amendment is lost. There are no further amendments at the desk. The question before us is, members, the question before us is the adoption of the report of the Committee of the Whole. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Please close the machine. With 42 aye, 18 no, and 5 excused, the report of the Committee of the Whole is adopted. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar until tomorrow.
Seeing no objection, the balance of the calendar will be laid over until tomorrow. Members, we have business to do, but first I'm going to offer Madam Majority Leader a moment to make some announcements.
Thank you, Madam Speaker. First, if we could clean all our food and drinks off our desks, that would be great. Secondly, I think we have earned it. So instead of starting at 7 a.m., I know, we will start at 10 a.m. tomorrow.
Thank you, Madam Majority Leader. Members, we have some business to do before closing out. You are free to leave. Mr. Schiebel, signing of bills, resolutions, and memorials.
The Speaker has signed House
The
Bill
signing of
1001.
bills, resolutions, memorials will be printed in the journal. Message from the Senate.
Madam Speaker, the Senate has passed on third
The
reading
message
and
from the Senate
transmitted.
will be printed in the journal. Message from the reviser.
We herewith transmit
Message from the
without comment.
reviser will be printed in the journal. Message from the governor.
Honorable members of the
Message from the
Colorado.
governor will be printed in the journal. Madam Majority Leader.
Madam Speaker, I move that the House adjourn until 10 a.m. on Saturday, April 1st, and the dress code tomorrow, casual, jeans.
Seeing no objection, the House is adjourned until 10 a.m. on Saturday, April 1st.